All right,
Welcome,
Mark,
everyone.
good to go.
Thank you, Brian. Welcome, everyone, to this meeting of the Subcommittee to Study Regulatory Change. I'm the chair, Mark Henriquez. We are continuing our discussions about exploring different types of regulatory to change to see what changes, if any, we want to recommend that the State Bar study further. I want to remind everybody of their duty to avoid conflicts of interest and the appearance of conflicts in performing the duties as a member of the Committee to Study Regulatory Change in the North Carolina State Bar. Any member of this subcommittee who's aware of any personal conflicts or appearances thereof should disclose those during our discussions at the meeting. I think today is really dedicated to one of the most interesting things that we've talked a little bit about, but have not done a deep dive in, and that is regulatory sandbox. We heard about that in some of the presentations that Brian did at the beginning, now I think over a year ago. I'm sure you all remember it like it was yesterday. And you've gotten updates about what some of the other states have done around regulatory change. But that's what I really want to focus on. Brian, I think we now have a quorum. Am I right on that? Let's approve the minutes first, just as our one administrative item before digging in to regulatory sandbox. Those were circulated by Brian earlier as part of the agenda. I've reviewed them. And can I get a motion to approve those minutes?
And before we get the motion, I was going to say, Mark, I have one correction. I had Marcy listed as attending, and Marcy was not in attendance. So she let me know about that. That correction will be made.
Excellent.
Motion to approve with the friendly amendment.
Thank you, Jeff.
Second.
Second from Todd. All those in favor say aye.
Aye.
Aye. So it seems unanimous, Brian. So those minutes are approved from our July 27th meeting. So with that, without much further ado, Brian, anything you want to say before we turn it over to Jeff?
No, I just think this is going to be the Jeff Kelly show, or Jeff and his working group. I think we're all excited to hear his take on the regulatory sandbox.
Excellent.
Awesome. Well, thanks, everyone. And before I kind of dive into a slideshow, let me say at the outset, I can make this available afterwards. It is going to be denser than I would typically do for a kind of traditional slideshow. So treat it like a fact sheet. You don't have to worry about keeping notes. It'll be available. But I'm going to divide this up into a couple different chunks just because we did have a presentation from the Utah group back in November, and a lot has happened even for Utah since then. So kind of going to take a big picture of, what's the overview of sandboxes, who actually has one kind of either implemented or currently in process, what states are considering it, and then a few other jurisdictions that are relevant for consideration. And then I thought it'd be very helpful just because we can talk about the abstracts of sandbox all day and never exhaust sort of the hypotheticals we could do. So what I thought would be very helpful is to run through just a few of the specific examples of the kind of risk categories that Utah in particular has approved. These are entities that are actually in operation as we speak right now, and give you a few examples of how those different categories play out, because I think it helps give a little bit of contours to the discussion. And then from there, I'm going to dive into within hopefully an open discussion, but there were 6 questions that Mark and Brian and Alice asked me to answer that's more North Carolina specific about kind of the logistics of this and helping us think through, okay, if this is an idea that we're broadly comfortable with, how can we move that from kind of broad theory of a study committee to something that the State Bar Council can actually recommend or do something with as far as forming a long tail implementation committee that would ultimately be responsible for deciding which of these hypotheticals we should adopt. So thought that'd be a little bit helpful before I give you just a big screen. And here we go. All right. There we go. Can you see it? All right. So the big question, one of the best definitions of the sandbox that I found, at least for kind of our purposes here, is that it's a regulatory environment that permits the delivery of new models and services under careful oversight. And I can't emphasize enough, this is still a regulatory construct to test the interest, viability, and consumer impact and inform policy development. So the hope is that, there are models that we're going to say you can apply and that we don't necessarily see risks for theoretically, but they may not have an impact, but it's still worthwhile to open them up to some degree. So that's the gist of both the viability and consumer impact piece of things. And also, there are probably theoreticals we could throw out there that no one's going to apply to. So again, testing the interest, but we don't want to be prescriptive on the front end and telling people what we think innovation should look like is kind of the hope of this. So that really brings us to who's exploring this, where are these sandboxes, labs that people are calling them. It's the same general concept. It's a regulated environment for us to test. So the active ones are Utah, which is in full operation. You're going to hear me talking about them a lot because, again, I like to talk in concrete terms as opposed to speculating. But our friends north of the border have also been making pretty bold moves, with both British Columbia having completed their initial round of applications in, and they're operating under what's basically a no action letters model, where the applicants apply to this program. The Law Society of BC will look at the proposals and essentially issue them letters saying, we're not going to come after you for the unauthorized practice or violating the rules if you prescribe to these particular requirements. And there's also reporting aspects of that too. So they'll set the terms that you're allowed to kind of have a narrow operation. And I'm sure that you're chomping at the bit to look at the details, but those are all in your materials if you want to thumb through those letters. And then Ontario is a newcomer to this. They approved a 5-year sandbox, and they are currently receiving applications. So the first sort of pilot cohort will be, I think, announced somewhere in September, but its approval is by September 2021. And then after that, it's just going to be on a rolling basis. Other jurisdictions that have been looking at this and have varying degrees of reports that, again, are in the reference materials. And I know that we've exchanged, especially California and Washington, and I think even Florida in past meetings. But the big ones to watch are, again, California, just because of how many lawyers are there. That's the ATILS task force that's considering a broad range of regulatory reform, including a sandbox. There's Florida, which pretty recently announced that they have a somewhat more A to J focused sandbox as well, which, again, I'm not entirely sure of the exact differences on how that will play out. But again, it's sort of messaging on that piece. Washington released their blueprint, which again measures different components of the impact on the access to legal services crisis. And then there are these, I included Illinois and Connecticut because I know they're working on it. I haven't seen anything public. Just from talking to folks that are engaged in these discussions, I know that they're actively looking into this, and it's sort of like us, where I think the broader world might be aware that we are having these discussions, but where they lie, where the opinions are, and what the recommendations are still somewhat unknown. So again, a decent amount of activity, but no specifics to draw from there. And then again, the honorable mention I put out there, because while we're talking about what rules we might consider relaxing under supervision, Arizona just did away with certain rules. And so, they may not appreciate, but I always say that Utah put in the sandbox and then Arizona said, hold my beer. So they're in this, and they are sort of by definition a laboratory and an experiment. So we can watch them and see whether their occurrence of complaints go up or anything like that. But in any event, they're squarely in the game. So this really brings me to the happy part of the conversation, which is why are we having this conversation? This will be very familiar, a lot, especially the data points, to folks that have been here for the past couple of meetings. But the real problem that we're trying to address by exploring some type of a regulatory sandbox is that the one-to-one service model that is being facilitated, even through some of the regulatory reforms that we're considering, is probably not going to be enough. And so a popular stat that a lot of advocates for this type of reform point to is the World Justice Project. And they actually pull now outdated data and say that we were tied for 99th out of 126 countries surveyed. It's actually gotten worse. I pulled the data that just was published recently, and we're actually both the bottom of our kind of regional ranks, income ranks, and we're near the bottom in terms of the countries surveyed in terms of access. So that let me give you a little bit of context and say we have a fantastic legal system. That's something that the sort of the integrity of the system, all other ratings, the United States is doing very, very well. But in terms of who can actually participate in that, it's, as you see there, pretty grim disparity there. So again, familiar stat that you've been bludgeoned with is that the Justice Gap publication by Legal Services Corporation, this was in 2017, determined that 86% of legal problems reported by low-income Americans received inadequate or no help. And there are other economist findings that if we were to sort of fund our way out of this through giving more resources to legal aid, based on current funding levels, we would have to essentially 30x what we're doing. And same with pro bono hours, where it's going to be moving to, if we want to mandate 200 hours of pro bono work per year, then maybe we can put a dent in this. I think the answer is sort of an and, not an or exclusive piece. But at the end of the day, I don't think it's realistic to say that one-to-one is going to close the gap. So that brings us to, I've talked about all my fancy, international and national studies. What about North Carolina? We've heard in detail from the Equal Access to Justice Commission, and the timing of their report, which was pre-COVID data, by the way, very timely. And they identified that a massive barrier here is cost. And so I know, again, I'm really being a bright and sunny speaker here, but part of the problem we're going to have to grapple with is that there is an economic component to the access to justice question. Now, there are other practical questions that we can work around. I mean, things like the mobility questions I'd lump together. So, missed work days, I don't know how to find a lawyer. Those types of issues are something that we can adjust different platforms for. But at the end of the day, if the barrier to entry and have someone to guide you through the process is prohibitive, then we're essentially making a decision. The status quo is either you find some way to fund your way towards a lawyer, or you go it alone, which I think seen some pretty depressing stats on how that plays out for self-represented litigants too. So now that I've laid that out for you, what does this do to actually help the problems I've laid on your doorstep here? So the goal of this is to create a structured regulatory environment. And we're looking at the risks that would be accompanied with things that I think if we were debating the rules sort of in a vacuum, we could see on one end, there are probably instances we could think of that if we allowed them to operate, that wouldn't run afoul of the spirit of a rule or restriction that we've put in place. But at the same time, I don't think that folks are comfortable just outright abolishing, like Rule 5.4, for example, here anyway. And so the question is, how do we get the best of both worlds, or at least some type of a compromise position? And that's really why I've been pretty bullish on the Sandboxes. I view this as a middle point. We're not saying that the rules go away. We're just giving a vehicle or an environment that lets us test certain things and pre-approve certain things to operate and generate data that will actually inform the discussions, as opposed to smart committees like this talking ad nauseum, but ultimately we can't really reach a consensus. So the hope would be that if we, like other jurisdictions, are either implementing or seriously considering this, we would agree on some type of a regulatory body that would allow for experimentation that otherwise would be violative of the rules, that it would create an opportunity for us to assess proposals that are presented. I mean, they're not greenlit out of the gate, or even sort of presumptively greenlit, but proposals, and that informs, again, the regulatory aspect of the state bar that would weigh and say, okay, you've presented something we didn't even think of. That's actually a very good idea, but we'll need for you to report this type of data. We'll need to do it on this basis. You can't do X, Y, Z, right? It's something that no longer are we having to have prescriptive rules, as opposed to an opportunity for it to be a dialogue that hopefully be engaged in good faith. And again, there's also another piece that is, again, this is a factual point from Utah, is that right now, if I were to submit, or someone in the public were to submit a letter to the North Carolina State Bar and said, here's my business model, is this UPL? They would probably get a response back from the Authorized Practice Committee that says there's no current consumer complaint against you. Good day. And that's it. And so they're either having to not do that business model that may not be UPL, or they're going to have to roll the dice and wait until they get a letter of caution or something. So this in Utah has actually been a process by which people that are close call UPL, is what I'll call it, are able to apply. They're denied admission to the Sandbox, but they're essentially told you're denied because you don't actually need to participate in this. And so again, it's another layer of allowing people to contribute to this growing problem. And then the last piece of it is it allows us to generate data about service models, legal needs, and regulations that are in effect that inform future discussions, so that we can hopefully have a better grasp on, are there opportunities that we're missing? Are there things that we presuppose were harmful that weren't? And I promise this will be the only massive word block that I will read to you verbatim. But from Utah Supreme Court standing order creating the sandbox, it's a very familiar problem that they're framing. And I think that those of you on the committee that have worked through the issues over the past year, but also, frankly, if you're like me, you've lived trying to implement these solutions too, it will hopefully resonate with you. So in Standing Order 15, the Supreme Court said, for years, the Utah Supreme Court has made combating the access to justice crisis confronting all Utahns of all socioeconomic levels a top priority. To date, the Supreme Court, along with the Judicial Council, the Utah State Bar Association, have worked ceaselessly to improve access to justice through many initiatives: the Utah Court Self-Help Center, the Licensed Paralegal Practitioner Program, Form Reform, and Online Dispute Resolution Program, to name but a few. What has become clear during this time is that real change in Utahns' access to legal services requires recognition that we will never volunteer ourselves across the access to justice divide, and that what is needed is market-based, far-reaching reform focused on opening up the legal market to new providers, new business models, and service options. And so, again, I think that there are some things that North Carolina has done well that are not on that list, but many of those initiatives that they've implemented to try and address the access problem, we are either actively considering right now or have tried ourselves. And so I think that it's certainly a persuasive point that we've taken stock of what we're doing to try and address this on a one-to-one basis. And ultimately, there needs to be a little bit of an opportunity to try something different. So Utah, a refresher for everyone, since like Brian said, I know that you know this already, you remember and have active recall, but let's talk about Utah because it's the one that is furthest along and has the most data to work with. And I'm noticing as I put this in PowerPoint, the formatting changed. So please excuse that there's multiple 1, 2, 3, 4 as opposed to 1, 1, 1, 1. So what Utah's process is focused on is, again, it's risk-adjusted outcome-based regulation. It is based on giving a few examples that we'll get into about flexible service models and structures. And we're not going to, on the outset, presuppose what is going to work or isn't, but we're going to say these are things you can consider as part of a proposal. And it's heavily data focused with a lot of ongoing oversight. There's a lot of reporting, and it's something that will ultimately inform the sort of final approval to operate as well. So, that's what we're talking about in terms of what the regulator does. Who is not allowed to participate is something I think that gets lost in the weeds of this. And this isn't going to be a vehicle for someone that's been subject to attorney discipline, for example, to circumvent that, the consequences of their actions in the council's determination. So you have to disclose that you have disbarred lawyers or suspended lawyers, and they can't have a more than 10% interest in a company, for example. The sandbox is also not something where I can go practice in Utah just by submitting an entity and saying, hey, I'm going to provide, a partially owned subsidiary that is going to offer, services in the area. That I would still need to go through the attorney, licensing process as well. And then finally, even though it's not a categorical bar, one thing I think is important to think about is the Supreme Court determined that persons with a felony criminal history, that has to be disclosed and considered because it could have an impact on sort of the elevated risk to consumer harm. And that's part of it that is relevant. And then I'll dig into this a little bit more with some specific examples, but this is an ongoing assessment too. So the Utah Supreme Court in December decided to halt consideration of what they're referring to as bare referral fee arrangements. And that was a large volume of what came in on the outset. And again, they allow referral fees under certain contexts, but if it's only, there's no other business model, then you pay me to give me a referral, then, they still are not comfortable with the conflicts of interest and pulled that. So the process in Utah is a pretty detailed application process. On the front end, the candidates submit, like I said, their proposal. They talk about what their business models are. They go through a pretty robust risk assessment. and talking through both what they're doing to identify those risks, mitigate them, and also provide a process for, again, we can't exactly determine what services people provide, but the point is, whatever that is, you also need to give some type of a remedy and a process to the potential consumers. And there's also an explicit assessment of how does this benefit the Utah public, right? It's not just that this is a smart model that benefits attorneys. It's focused on how does this actually address the problem that we're trying to solve here? And you need to explain how that's going to essentially provide higher quality, more cost effective, and more accessible legal services to the target consumer. And then there's also, again, like I said, disclosures about who can participate. Is this a circumvention? And so that's the front end of the vetting that's submitted. So from there, the office will take that, and it's an iterative process that actually has been pretty interesting to look at. And again, I won't fault anyone for not digging into the materials and applications, but what you can actually see in the materials is the office will look at the proposals, and they're making pretty significant determinations where in some instances, the applicants have identified that they thought they were a high risk category, and they've gotten feedback that actually you fall here, and this is why. And likewise, there are instances where the assessment of risk was too low or inadequate, and so they've adjusted it, and then they make recommendations to the Supreme Court, who actually operates as the regulator in Utah, who then makes further determinations and sends it back to the Office of Innovation in this case to continue to monitor. And there's, depending on the risk level, monthly or quarterly reporting requirements among other disclosures. And so that's really the basic process for Utah. So I've talked a lot about the risk categories, and I will continue to talk a lot about them, but what exactly are they? So here is the list that Utah provides in their office, Innovation Office manual, and they categorize them based on really it's business model first and then operation second, if that makes sense. So we're looking at sort of who owns the entity as sort of a lesser risk per se, with sort of employment and management or minority ownerships being on the lower side. When you start getting into bigger pictures where there's alternative business models where suddenly lawyer ownership is the minority interest, that creeps into the moderate. And then when you get into more active operations and management and cash flow, as well as delivery of legal services at the more extreme end, that's where you get into the higher reporting requirements. And again, as we sit here right now, and we'll get into it, there's only one high risk authorized entity, but it really runs the gamut in terms of you identify which of these different permutations you're going to propose, and that's going to help at least start the conversation on how you will be regulated. So right now there are 4 low risk authorized entities, and the sort of minimum amount of time that they would spend giving their reporting would be 9 consecutive months of compliance. So it's something that requires a pretty consistent track record, even if this is something where we're only talking about a minor non-lawyer ownership or something along those lines as part of the business model. And I've used this example before, but I think it illustrates the picture pretty well. The Bluebee bankruptcy is an example of minority non-lawyer ownership, and actually it's because they gave 10% of their interest to a lifelong or long-term paralegal, and the idea being that it both benefits because the paralegal employee is rewarded for her high quality work and commitment to the firm, and it was an incentive for her to remain with the firm that she's now developed a lot of experience with helping their clients. And the sort of justification that the approval of that looked at was really the retention of high quality support staff was likely to increase both the reach and quality of consumer service. And again, this has more to do with the attorney's ability to know that the sort of rate at which their supervision would be stretched, you've worked with them and they have an ownership interest. They have some stake in the ongoing success of your business. They're not just going to kind of cash in here. The other 4 have somewhat similar considerations, but again, I think it's pretty interesting to walk through them. So the other, again, access to justice or access to legal services pieces that are served by the other low risk category models were that joint ownership between lawyers and non-lawyer tech and business experts helped facilitate innovative services. And so that's something that we've talked about, where right now, unless you're a firm with a large budget, you're probably not going to be able to attract top talent because a large firm, you can pay a large salary. But if you're getting into your medium or small firms or solo firms, even for that, the likelihood that you're going to be able to kind of pay competitive salary versus someone who's used to getting an equity interest in a startup, for example, is going to be very challenging. So it's something that helps with easing that tension and aligning the talents. Another part of it was that there was a combination of kind of, depending on where they operate, they had limited licensed technicians in some jurisdictions. In Utah, it's paraprofessionals they have, but another example provided essentially a DIY plus model where there are still lawyers involved, there's still lawyers, they're supervising it. But the hope is that by having a different way of structuring their model, the consumer could essentially opt in for help on transactions as needed, and that let the lawyers provide their service at a lower price point. And then the last authorized entity, really what they did was they had a little bit more expertise in the dental area. So it's really, they worked with professionals in the industry to basically broker both purchasing and winding up of dental practices, which is something that they would have had to come up with a little bit different structure to get through. And by the way, I should say, I know I ramble on. Feel free to interrupt me at any time. Just a casual reminder on that one. This is the big category where most of the entities are, and it's the kind of moderate risk, which, as you might imagine, go figure, people aggregate in the middle, and they have to have a full year of no strikes whatsoever before they would be even considered for exiting the sandbox. And so again, you have to have a pretty healthy track record to get through that. So the first one is Holy Cross Ministries. I'm going to give it an example, and this is a non-lawyer provider with lawyer involvement in the process. So the idea behind that is the client or consumer is going to interface with someone that has been trained in an area of law or practice area, and they may have some ability to talk or work with the lawyer who's still providing supervision, but at the end of the day, most of the day-to-day work is being done by the person who's not a lawyer. And I thought it was pretty interesting drawing a comparison between Holy Cross Ministries and a familiar program here with the North Carolina Faith and Justice Alliance. So the Holy Cross Ministries in Utah is, again, it's a 501c3 organized that's supported by multiple religious organizations, and they provide basically emergency medical debt assistance, and they also have an existing legal immigration program. And what they do is they train what they're calling community health workers, which there's an established curriculum, and their goal is for them to be basically bilingual medical debt legal advocates that provide limited scope legal assistance to both medical debt and related collateral issues. And if you look at, again, it's something that it's not so far outside of what we're trying to do here, but one thing I think is interesting is the clinical model in North Carolina essentially requires 5 different levels of handshaking, right? You have the community member with a legal issue, clergy or religious staff leader, the Faith and Justice Alliance as the intermediary, which then interfaces with the attorney in the community at large, and then they pull in outside resources. So we're certainly trying to solve this problem, but again, it's something that could probably be done in-house somewhere with the right supervision and with the right approval, because we're trying to accomplish that just under existing rules right now. Another one that's definitely a different one, and this is intermediary platforms. And so there are a couple of intermediary platforms. I thought that Zyra Connect, and I'm probably mispronouncing that, was probably the most understandable in terms of kind of what this means. And so what really, this is the kind of Uber platform, right? Where you have a virtual marketplace that connects lawyers with the potential clients. And as part of this business model, they are offering tools, video conferencing, and billing functionalities. So the idea is you don't have to use their tools, but for any lawyer that wants to become involved in this, they at least have the kind of basic items you're going to need to move to a virtual practice. And their incentive for that is that if there's a successful referral that's made and a successful engagement, they'll receive a fee from that initial service. And that also would extend to basically their limited professionals as well in Utah, which we don't yet have here, although that's under consideration. So this is kind of what I was alluding to when I was referring to the bare referral fees. It's very different than just saying, hey, I'm going to have someone that every time someone calls them up and says, I need help with this, you call me and I'm going to give you a referral fee every time they talk to me. This is a static platform that provides tools. And so it's nice to see how the Supreme Court in Utah, anyway, has used the application process, has used the approval process to identify kind of where some of these issues are, where there's still a much bigger concern about conflicts of interest when we're only looking at bare referral fees. And for that reason, they halted consideration last December. That's been referred to a different standing committee within the state bar there, or the judiciary there, judicial council, and they are working through that. So it's a good opportunity to, again, parse out the issues and see how one, I think, is a little bit more palatable and manageable versus kind of ad hoc referral. And then, since I only have one example, I'm going to talk about it. The only high risk entity takes 2 years of good behavior and good data to even be eligible. And even then, the Office of Innovation would reserve the right to add and extend it or add terms. So this is AAA Fair Credit and People's Legal Aid. It's a non-lawyer provider without lawyer involvement. I know. So let's break that down a little bit. What they're doing is a joint project, again, similar to the Holy Cross Ministries. It's urgent medical debt collection in Utah, and they're looking at consumers who otherwise wouldn't receive legal assistance. And so what they're doing that's different than the Holy Cross Ministries is they're piloting a medical debt legal advocate program that's not going to be actively supervised by an attorney. So the actual education piece of this, the training certification, is being run by a innovation lab that's currently housed in the University of Arizona, but it's going to be taught by University of Utah faculty. The program right now is slated to be about 70 to 80 hours to actually complete. And even though attorneys won't be actively supervising the MDLAs, they will be available as a resource, but again, not actively supervising. And in instances where it's just a complex issue or case, the MDLA will flag that for attorney review and pass it on. So again, the hope is that this would be an effective triage legal service that currently, we wouldn't be able to assign attorneys to supervise things actively. And so this would be a resource that couldn't exist under current rules, at least in North Carolina. So right now are getting the first of the 6 questions that our team asked me to look into, that if we're looking at implementing something like this in North Carolina, we need to understand how we would go about doing that and what we would need to do. So the first question is this something that requires new legislation? And I think that the safest, clearest answer would be say yes. I think that if we wanted to get very clever, you could go the sort of no action letter route of the Canadian Law Societies. But at the end of the day, this is something that would probably want to accomplish through a narrow amendment to the authorized practice rules. And it would be something that would essentially allow the state bar to establish an exemption for innovative solutions under a program to be approved by the State Bar Council and Supreme Court. And I know that presenting anything related to the practice of law to the General Assembly is a bit of a sore subject. So one thing I thought was helpful to flag is that the General Assembly is already considering a bipartisan fintech sandbox bill, and it's receiving favorable treatment. So it's something that, at least as far as the current thoughts and sensibilities in the General Assembly, is that allowing for some type of flexibility in regulation is going to become increasingly necessary as we especially have technology introduced to various areas of practice at various areas of business. The ability to keep up with that and sort of manage an evolving both regulatory construct and evolving technology is going to be more and more challenging. So we need to find ways to enable more responsive management of that for consumer protection purposes. The next big question is how we actually fund.
Jeff, can I interrupt you? You talk about legislation, and I think we need legislation to allow the sandbox. Does that include, permission for the state bar to then approve the business? Let's say it's a similar model with a 12-month or 24-month wait period. you know, would you still need some other revision to allow them to operate in, you know, for example, in that high risk one you just talked about where you have legal services from non-lawyers? Does that all get encompassed in some enabling legislation, or do you have to think about subsequent modifications of either the rules or the practice of law statute if certain innovations, you know, are submitted for approval outside to work outside of the sandbox?
So I think that you would want to have an enabling statute, and that would likely form a standing committee or some aspect of the state bar that would be kind of retain the regulatory authority. And it would be through administrative code or other handbooks that are adopted and approved that you would have the specifics of, you know, which categories are we going to allow in. And that way it makes it so that if we go through all the trouble of getting this approved and we decide either that something was far too restrictive, or in the case of what they did in Utah, where something was more or less improvidently too broad, the, you know, whatever that body would be would have the authority to, with good advice, pull it back.
Gotcha. Thanks.
Jeff, this is Brian. Would you take a couple of just minutes to talk about this current bill, just to explain just what are they trying to accomplish? I think it's a really good example of what's currently before the General Assembly, and just kind of so we're all on the same page of what's actually being considered.
And if you haven't seen it, it is at the very end of the agenda that Brian circulated. The very last 2 pages are the actual bill. But yeah, it's a good idea, Brian.
Yep. And if I didn't include that, I can send around. There's a pretty good bill summary as well for folks who want to dive into a little bit deeper. But the idea is that it's borderline impossible to keep up with the number of financial instruments. And again, fintech, take a step back, fintech is a lot broader than maybe folks here are familiar with. So maybe I should start there, where the idea is that there are a lot of different platforms and ways of dealing with value or negotiable instruments that are tech enabled. That classic examples that people think of is how do we deal with the handling of cryptocurrency, and what does that do in terms of our ability to manage value, for lack of better terms. And so the current rules, and including under the Banking Commission, there are working groups like us that are trying to talk about that. But the idea would be, rather than continuously having to go through the amendment process, what the bill is proposing is to create a separate office under the Department of Insurance, actually, that would be essentially a sandbox, much like what we're talking about here, where you're not going to run into securities issues, you're not going to run into different banking regulatory violations if you apply under and qualify under certain circumstances. So again, they're dealing with the same issues we are, which is, we know that there are legitimate businesses out there. We know that this is potentially very beneficial to consumers, and particularly consumers of different backgrounds and demographics. But we are also deeply concerned that if we enter prescriptive litigation, there we go, Freudian slip right there, prescriptive legislation, then we will be getting lots of challenges, and also both ways, that it's too restrictive and that also there's a lot of consumer harm. So the current comment period on I think it's in committee and it's on its 3rd draft, but it's been pretty interesting to watch that process, and I'm tracking that for kind of my own practice off from this conversation as well. So that's why I'm pretty comfortable saying that while I don't ever want to forecast what the General Assembly would do, a lot of the discussions and debates and concerns are very familiar to the ones that we're sharing here. And so I'd like to think that this would be a receptive environment for that type of change. All right.
Any other questions for Jeff before we resume? All right, please proceed.
I might have preempted them, sorry. All right, you guys can see the slides? All right. So big question number 2. Oh,
we don't see it, Jeff.
You don't see it?
No.
Not yet.
There we go.
We're good.
All right. So next fun topic is how we're going to pay for this, right? Innovation is, despite popular belief, not free. So, one thing that we talked about very early on before any sandbox had really had launched in earnest was, is this something that we can pay for with the fees that will be charged of applicants and successful people that are approved to operate, and then further pilot fees? I don't think that's realistic. And part of that comes from talking with the team at Utah. They've been very transparent about the fact, and you could probably do the math from looking at the handful of authorized entities, that unless we're talking about massive, prohibitive fees that would frankly frustrate the purpose of these types of programs, you're not going to get there through, and at least initially, it may be sustaining down the line, but your startup costs are too high. So the good news is that at least in Utah, their project is entirely funded by private grants. And then I think their most recent year of operation was a combination of private grants that were matched by the courts there. So the interest in supporting these types of initiative is certainly available. And I know that in the past, even in North Carolina, we've been able to fund programs either through different state bar funding, or I think that, and maybe if you're wondering why I have Keith here, I'll introduce him later. There's another aspect of this that the Academy is very involved in helping develop these types of programs too. And a popular way of getting academic programs off the ground is seeking funding through grants. So that would be sort of the short answer of it. But I'd be curious to have others' thoughts on this one in particular, of not only where the funding might come from, but also what that means for the structures of a regulatory body or the partnerships that we could have. Or is the hope just that if we get this far, I will track down people and come up with money?
I don't hear anybody racing forward with checkbooks open, but
okay.
Keep working on that one, Jeff.
All right. Well, and just to reiterate, the Utah Sandbox is funded by the State Justice Institute, National Center for State Courts, and I believe that the Institute for the Advancement of the American Legal System, which is based out of the University of Denver in Colorado, is also contributing, although I didn't see that on their line item. So that's something that, in full disclosure, Lucy Rica, who is the executive director, has been very gracious and has offered to provide whatever information we need. So I trust that information is there. I just didn't put it on it because I haven't seen that part yet.
Jeff, can I ask a question?
Go for it.
With all the other jurisdictions that are kind of considering sandboxes, have you seen anything about how they've proposed funding their sandboxes? I'd imagine Utah had somewhat of a benefit of being the first sandbox, so they were able to get some of those grant dollars that folks were willing to give out there. But have you seen anything about funding proposals for the other jurisdictions?
So again, most of those are through grant fundings. And again, for those that have moved past the, again, study phase, they've been able to identify. And we're sort of in this phase where, I can tell you there are places I would approach and I would be reasonably optimistic about the ability to secure funding. But right now we're a study committee, so no one's going to line up and say, yes, I will commit to some indefinite point in time to fund, a six-figure grant, when there are other jurisdictions that could be there sooner. So, it's general allusions to the grant funding that likely exists out there. And again, part of why you're seeing names like ILES pop up, that's the Institute for the American Legal System, is that academic institutions certainly have an interest in facilitating these types of projects, and already frankly do that through clinical programs, just to a lesser degree. So again, it's something that I view as being very compatible with that type of funding and interest.
Thanks. And it's a good point too to me to remind this committee, as you say, Jeff, we are a study subcommittee. So our role would simply be to decide, do we think the idea of a regulatory sandbox is something the state bar should explore? I think much like we did with, limited licensure paraprofessionals, the idea would be if this committee votes at the end of today or whatever discussion we want to have, that this is an idea to recommend, we would be recommending to the issues committee and the executive committee that they move forward. They would presumably then appoint some committee to actually look at the logistics about what it might look like, including the feasibility and the funding and the structure. So I have asked Jeff to present kind of how it might look, because it's very hard in the abstract to just say, oh, Sandbox, so I like sand, I don't like sand. I think it is more meaningful to put some structure around it, in both what's done elsewhere and what it might look like here. So I appreciate Jeff and want to let him continue doing that. But at the end of the day, we're not going to be voting on any particular program. Ours, just like the other ideas, is more of a thumbs up, thumbs down. Is this something the state bar should pursue? And that's what I'll be asking this subcommittee to vote on at the end. Go ahead, Jeff.
Yep, I'll manage my advocacy appropriately. So another question and we've seen this come up in other jurisdictions too, but what new technologies do we hope the Sandbox will permit us to explore? And I think in talking amongst ourselves, the general consensus is we don't want to say you must use a particular type of technology, or even that a proposal would require technology. I mean, I think that we would be encouraged and anticipate seeing a lot of, and because they're new and exciting and present new opportunities, cloud computing, mobile client service as well, natural language processing and artificial intelligence applications, to name but a few. But again, the hope is that we're looking at finding good solutions. We're hoping that people will give proposals that are more about the problem to solve, and then finding the technology to build around that, as opposed to the other way around. And just to borrow the mantra from tech and design organizations, people, process, then tech. So in that order. And the idea is that, this might surprise the committee to know, but I'm very bullish on technology. I enjoy it. I think it can do a lot for us, but I will adamantly defend the sort of a extremely competent, well-run team will probably outperform a mediocre emerging technology in most tasks. And so that's something that, while I hope that it's an and, not an or, we want to enable those good teams to emerge. We want sort of the talent around problem solving and boots on the ground to be just as empowered by this. So, unless people have a dying desire to see this be only about technology, for example, and that's the route that I'm blanking on which of the Canadian law societies actually has a technology component to their application process. I don't know that we want to be that restrictive. All right, so no questions, I'll move on and keep moving. So the next question was, what can we learn from the process used by other states? And the short answer is plenty. And based on the fact I've been talking about Utah ad nauseum, allow me to talk a little bit more, but we can learn quite a bit from them. So a few of the points that I didn't really tease out in that is that even though I gave everyone a few examples of each of the different risk categories, for the most part, as a kind of categorical description, I'd say that lawyers and legal professionals are still very prevalent in those authorized entities, and most are either wholly owned or in part owned by lawyers, and most of the delivery of legal services are through lawyers, or at least under their direct supervision, with the one exception of the paraprofessional that would essentially be trained, but again, they still have attorney resources at the end of the day. Another piece that we've talked about is there's an interesting point about, okay, is there going to be harm that comes from this? We now have data, even if it's very preliminary, and I'm somewhat hesitant to offer this as something that is really just ultra compelling, but is still very promising data. And that's because I work with data all the time. I know that sample sizes are something I need to be careful about. But from the Utah data, the ratio of harm related to actual complaints of the services was approximately 1 in 1,200. Which, again, that's something that I think, given that we're talking about pilot programs that have been in operation for, for the most mature of them, about 9 months, that's not a bad occurrence rate. That's something that is certainly not the end of the public or profession that we would fear. And so, again, this is about, we're acknowledging risks, we're managing risks, but at least there's something here that validates that those risks are not unwarranted, those risks are not catastrophic. And then the last was looking at the areas in which the different authorized entities are operating. And while there are some examples that kind of cluster together across the board, I thought that there was a reasonable coverage of certainly consumer legal services, and I could anticipate that broadening into other business services as well. So that's hopefully the last of Utah that I'll talk about for a little bit. Looking at the other jurisdictions, I thought that we'll have some good sources of data going forward. So again, this is something to keep in mind more in the context of if we recommend that the state bar move towards implementation and we're fine tuning what that could look like, by the time those decisions and public comment periods would come up, we would have data from Arizona, from British Columbia and Ontario at the very least, potentially other states that are moving forward. So hopefully it won't just be saying Utah, 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 but I'm happy to say that too, because we at least have data there. And the last kind of other state I point to is that Washington, D.C. has been at least allowing alternative business models for the better part of 30 years. So the fact that they have the lowest percentage of public discipline, again, at least encouraging from a no harm or lower risk of harm standpoint. I think Jeff, you're raising your hand.
Yeah, I just wanted to ask one quick question.
Yeah.
Do you know who's like gathering the data and doing the eval in Utah?
Yeah. So in Utah, it's the Office of Legal Innovation Services, and they have among not only do they have a board of volunteers that are assessing this, but they also have a dedicated data analyst who is essentially managing that process and aggregating the data. So they have a combination of professionals who have substantive expertise, but then they also have someone whose job is basically just to be a quant and to process that. So it's a mixture of the two.
Do you know if they're going to make that data public, or do you have?
So
yeah.
So the data is public. They offer reporting pretty frequently. So there's monthly reports that are very high level. And I'd also say that from a kind of sharing of information perspective, again, if we were moving forward with an implementation phase, that's something that the Utah group have been very transparent that they will make available. And I think that they've wanted to use their experiment as a teaching opportunity, not just for their jurisdiction, but something they view as being relevant to other jurisdictions. So let me turn your question on it a little bit and say, if there are questions that we have and they have that data, I would fully anticipate that they would cooperate. And I know that in their application packets, they actually require, or at least request, that participants waive some of the data pieces so that they can share it with other academic institutions and like-minded groups. So again, they built in the expectation that they would want to and hopefully be able to show as much of what's going on operationally there as possible.
Great, thanks.
All right, so I think the last ones are a little bit quicker, hopefully. So I spoke too soon, I saw my next slide, so I lied. But the question is, should the Sandbox invite national companies, North Carolina companies, or both to participate? And my sense on that, and I think the consensus of the group when we were talking, was that it probably doesn't make sense to have a restriction that you must be a North Carolina company and you can't operate anywhere else. I think that artificially restricts what, who could participate. Realistically, it'll probably be North Carolina companies. I mean, this is something that you look at the Utah group, there are folks from outside the jurisdiction that have come in, but a lot of them are local groups that have, want to adjust or transform their existing models to expand their ability to serve. So I would expect that both will be good for the ecosystem. There'll probably be a skew, at least on the front end, towards North Carolina. But at the end of the day, as long as you build in consumer protections, it doesn't really bother me if it's a North Carolina solely company or they're lawfully doing business here. So the one thing that we did kind of put out there for thought is we have an online document provider program in North Carolina. And there are restrictions on sort of, even if you're a California company that is selling website-based forms here, you can't require a North Carolinian to go litigate in California. You can't require them to go do things that would be essentially inconvenient to a North Carolina consumer. And I think that type of notion of fair play is something that should be built into something, especially when we're talking about experimental services. Okay, and I promise we're getting to the end of the slide deck, but the big question is what type of implementation time frame would be realistic? And I think this is helpful. Mark already forecasted a little bit of why I'm very careful to say this is a study committee. I want to be very clear that even though I'm talking in somewhat deliberately in terms of sort of what I think this could or should look like, it's mostly to focus the conversation and mostly to make sure that the idea of the sandbox doesn't continue to go in circles in perpetuity. So right now we're at the very early stage of this. Even for us to progress the conversation, it would need to go to the State Bar Council. And from what I understand, the next time that could happen would be October. So that's the sort of potential recommendation timeframe, again, earliest timeline. And from there, we would enter into the more substantive conversations about, okay, it goes from a good idea to what should it be or should it be? And even with that moving forward, based on other jurisdictions, which really is primarily, again, Utah, but others have at least tried to weigh in and forecast on this. It's probably going to be at least 12 to 18 months, especially when you consider that there's a General Assembly that would need to be involved. But really the three big steps that I think need to be keeping in mind is that this is also, to receive final approval and a public comment period. I think that's probably presumed that we would want to pursue a narrow statutory amendment like we discussed, which would be an enabling statute. Hopefully at the time that hits, there would be some consensus on what the ground rules might be, but point being, that's another sort of step that is not within the immediate control of the council. And then the time frame to actually, now that this has been greenlit, and hopefully we've been able to secure some funding to launch the initial pilot. So from the implementation committee being formed in Utah, it took them about a year to launch their initial pilot. And I think that's hopefully, again, I'm building in 6 months for us to try and go to the General Assembly during an off season. No one wants to break out the crystal balls and talk about what this could look like in terms of time frame?
Jeff, just a quick reference with it taking 1 year for Utah's implementation team to launch their initial pilot. What was that 1 year from? From the recommendation or the Supreme Court approval, or what was the starting point there?
It was 1 year from their report, basically saying we are now, or sorry, it was the Supreme Court's order rather, saying we are moving forward based on this report. And so they had to work on their handbook during that time frame. They had to pull together the materials for approval. So they didn't have everything worked out on the day the Supreme Court said, go do this, but they did have, again, ground rules. And I think that it was probably after they were given the approval to move forward in the public comment period, it took them another probably 4 or 5 months before they actually started soliciting the applicants.
Gotcha. Thank you.
All right, so I've been trying to funnel this into a little bit less of an abstract point, and so to kind of borrow from what I'm seeing other models based on, I think just quick visual representation might be helpful to think about. One of the big points that maybe I didn't emphasize in this, but I know that Lucy of Utah emphasized when she spoke to us, was that the traditional rules, the traditional practice of law, lawyer licensing, if we add them paraprofessional licensing, that remains squarely in one column on the left side, where that's not going to change. If you violate those rules and are operating under those rules, then business as usual from the state bar's perspective. Instead, what we're looking at is essentially an administrator, and this can vary from jurisdiction to jurisdiction, but some type of an intermediary organization that will be responsible for processing the applications and overseeing the approved entities. So again, it's much like in Utah and in other jurisdictions' proposals, the applications are processed, they're presented to the ultimate decision maker based on those recommendations. And there's a little bit of an iteration there as well. They're approved and then they're monitored. But that is a separate pillar. And it's not that we're changing the rules at any point in time. We're just allowing limited exceptions based on specific examples. And so, this is one way that I could see this working. And the reason why I use Sandbox Administrator is because one of the practical concerns we've had, at least in some of our discussions, is who will be responsible for pulling together resources, who actually can manage this type of a process, and like Jeff asked, who's actually looking at the data, and who actually has the expertise to look at the data. So that's something that I built this into a little bit of a flexible suggestion, but hopefully this is concrete enough that you can see how it could work, and enough that you can see what enabling statutes could look like. And ultimately, again, hopefully that the state bar retains its regulatory authority over everything that's in the left side. It's just that, again, with advice and input from a standing administrator, could deviate from that. So I'm going to hop off of screen share and hopefully open this up, but I can pull up slides if anyone wants to go back to anything too. I think you're probably tired of looking at just that.
I know you've invited Keith to join us. Jeff, is now an appropriate time? Do you want to introduce him and let him speak for a minute?
Yep, absolutely. So one thing I should say at the outset is that at the start of the month, I was affiliated with Duke Center on Law and Technology as a fellow, and Keith and I have been working together, especially over the past month, to talk about a lot of different projects, and most of them relating to data governance and digital advice. But one of the conversations that kind of merged with our discussions here is that if we're looking at different institutions that might be able to assist or lend expertise, one of the thoughts that, at least amongst ourselves, we thought was setting up an administrator where potentially the Center on Law and Technology could be one good example. And so Jeff Ward, who's the executive director, who actually spoke to us on legal technology in their Duke Law Tech Lab, I couldn't tell you when, but at least a year ago, couldn't be here. But Keith is responsible for both the Access Tech Tool initiatives. He does work with their clinics, and he is also responsible for their digital design studio, among other projects that I won't get ahead of him on, but I thought it'd be helpful to have him here too as well.
Thank you. I think that's helpful. Keith, anything you want to say just by way of introduction?
No, I think I don't have too much to add to Jeff's introduction, especially in the spirit of the study committee. But I guess what I'll say in just a couple of sentences is what we are really interested in, and what excites us about this is the opportunity to help states learn what a post-sandbox world should look like, right? And how, as we're thinking about new ways to deliver legal services, especially in the access to justice context, can we build infrastructure that supports people's faith in the legal system and in the rule of law. And so we're really interested in that intersection, and these really early study conversations with Jeff have been really exciting. So
I think that's great. Yeah, no, and I appreciate it. Again, we're not establishing a particular sandbox. We're certainly not picking an administrator. I know the center's not offering to serve as the sandbox administrator, but I found it interesting and encouraging that there's interest in that. And that to me solved one of the puzzles I've always wrestled with, which is who the heck's going to handle all this work? How's it? And you address the funding, but it's both funding and manpower. It is obviously a lot to actually review the applications and decide. And I think more than certainly existing state bar staff, although, could do, or even, trying to add staff. So I think partnering with some entity, is an exciting option. And again, not something I'm asking this subcommittee to vote on, because that's an implementation detail. But I think it's a factor in me thinking that it may be worthwhile to know that there are partners that might be interested in helping, facilitate that kind of role. So let's open it up for questions about, again, Sandbox in general, what it might look like, anything you heard from Jeff's, whether this is a good idea, bad idea, or there's more you want to learn about it. So, because I think it's a good overview, and I know there's a lot of new materials, but there's good stuff to discuss too. Heidi?
Hey, Mark, I have a question. And I was listening, but I'm not sure I completely understood the full answer. on what the cost of this could potentially be? And I heard you said it could be funded by grants. I mean, who's giving those grants? Would there be any potential conflict of interest if any money was privately, I guess, contributed by law firms? I look at it from a cost perspective because I can see that being an inquiry that, people would have. Any thoughts on how much we're talking about, Jeff, and where the money would come from?
Yep. So the granular example of the sandbox in operation that actually has received funding is Utah has, I think they had a seed grant from the State Justice Institute, and that was for, I think, $100,000. And they had a match for that, which I think came from the National Conference of State Courts. And again, I don't know exactly where Isles came in, but I know that was funded. And some of that is public record. Others are requests that I fully expect to have, cooperation and support from the Utah team. But really, it's coming from large groups that are interested in the administration of justice. And again, I think that we'd probably want to look at if there's any sort of external funding or external administration. Certainly, this would be something that both for the administrator and for the state bar, they would want to do their own analysis on kind of potential for conflicts of interest, and also the ability to do something if it's a public institution, a public-private partnership. So that's something that could be worked out in an implementation committee. But again, yes, the source of funding is one part. The actual expenditure is something that we have good examples. And I will say that in talking through it, and again, if I had the exact budget information, I would share that immediately. But in talking through the budget on Utah, I was impressed with, it's a pretty lean operation. The full-time staff from that is an executive director and a data analyst. And those are the full-time, fully funded people. Everyone else is a combination of, much like how we're all here with our volunteer time on kind of council advice. That's one part of the assessment process, is essentially a volunteer board. And then there are also part-time administrative support staff, which were shared with the judiciary. So the administration courts probably helps in that respect. But at the end of the day, the sandbox proper was really only 2 full-time positions. Yep, go ahead, Camille.
I see several hands. Go ahead, Camille. I saw you. Yeah,
this is something I forgot that I haven't asked Jeff while we've been working together. So Jeff, I'm not trying to why did you bring this up now instead of in our work group? But do you think there's a possibility to share an executive director with someone who's already started an organization, to help with cost containment? Or do you know from talking to the people already, it's more than a full-time job?
So I will say that the kind of official answer from the Utah team is that Lucy Rico was full-time there, but I mean, she's also a fellow at Stanford, their law school as well. So I think that, there's a little bit of an opportunity there where it's probably still a full-time position. If you can find someone that's a glutton for punishment and volunteerism, then they may be able to make that work on kind of having 2 full-time jobs. But I also think that, sort of in the abstract, it's very practical that, especially someone that is an executive director, they could probably get by with being, at the helm or involved in a compatible organization. I think that you would run into more challenges if you get into someone that's doing the substantive data analysis, just because that is a much more involved, detail-oriented process. So if you're only talking about someone that's driving the sort of concept and spirit and approval process and the policy side, that could probably be shared. Data side, I would be very reluctant to say you want someone that is part-timer on that.
Mm-hmm.
Thanks, Jeff. Other questions? I know some of you have joined by phone. If you have questions, just unmute and go ahead. You can fire them away. think you addressed a lot of those questions in your in your presentation, Jeff, which I which I appreciate. And I think the fact that other organizations, other states have done this or are doing it is certainly something that is of interest, just because if we decide to move forward, you've got a little like the limited licensure thing, you've got other jurisdictions you can look at, both in terms of modeling the program, but also looking at what their results have been, good and bad, or what the challenges have been. So I think there's a lot of learning opportunities. And I do like, I think the fact that it's seen somewhat, this idea of a sandbox gets some bipartisan support in an era where not that many things are bipartisan. Some of the states looking at it are blue, some states are red. You get support across the political spectrum, may make it also something that has some political feasibility, which is always a nice thing to have in this day and age if it's something we ultimately need legislative support for. Other thoughts and questions? Jeff Summerlin Long, yeah, go ahead.
First, Jeff, thanks for that presentation. It was very well done. And I guess I'm just curious, that obviously was a very positive, almost advocacy type thing for a sandbox. Like, what are the potential downsides? Why would we do just a limited licensure instead of a sandbox? Why, I'm just curious about some of the advantages and disadvantages, especially the disadvantages, because we've already been through all these other things, and then suddenly, it's like, bam, here's something that kind of covers a lot of it. And I love the experimental nature of it and that kind of stuff, but I would love to hear people who think that this is a terrible idea or, something along those lines.
I'll soften that a little bit by throwing out there. One of the biggest things that concerns me is this, the best thing is this is an experiment. The worst thing is that this is an experiment, right? And so the hope would be that we would sort of build this in a way that you are properly assessing. And remember, we're not going to be, in theory, abstracting when we're talking about who can actually deviate from the existing rules. But at the same time, there is a risk that if we make an assessment and that harm is done, what can we do to both have adequate consumer redress or make sure that there are adequate protections if it's something that's down the line? So again, I'm kind of banking on this being a case-by-case assessment, and based on the application rate in other jurisdictions not being so overwhelming. But again, the hope is that even if it is overwhelming and there's not outstanding influx of applicants, that they're only getting approved as they can be approved. So again, can we get it wrong? Absolutely. And did the Utah Supreme Court feel like maybe they got it wrong on some things? Yeah, they suspended bear referral fees, for example, because they're citing conflicts of interest. So again, I know that I'm presenting this, and I obviously have perspective I'm very aware of is skewed in favor of this, but it's also coming from a standpoint that I sincerely believe that this is a process that is valid and used in other contexts that manages that risk reasonably. But again, that's, if I were to point to something that makes me uncomfortable, is the same thing that makes me excited about it.
Heidi?
So,
and then Alice. Yeah.
So in spite of what Mark said and agreed that the states that have tried this cover the political spectrum, one of the things that makes me uncomfortable is getting anything done in this political climate. And I wonder if there has been any attempt, in the not so distant past to sort of test the political waters on something like this. I agree it should be bipartisan, but I can hear how it might not be perceived as so. And so I just wondered if there had been any overtures towards our folks on Jones Street about whether this is something that's going to require a statutory, change. Is that feasible now or next year or the year after that? Not to be a buzzkill, but
no, I think it's a great question. Well, and I turn to our state bar historian, Alice Mine, to maybe answer that. But you had your hand up anyway, Alice, so there may be something else you wanted to say.
And actually, that was kind of
question. That'd be great.
That was kind of what I was going to address, Heidi. I have always thought the sandbox idea was interesting when we started this whole process and study. I thought it was interesting, but I couldn't quite figure out how would we do that in North Carolina, where all of our UPL law is statutory and the court is not really involved in the oversight of that aspect of the practice. But I think the fact that there is a bill that's moving through the General Assembly, this FinTech, I think is the right name, which it's a sandbox concept, and it seems to be getting a lot of traction and being really supported. That to me is very encouraging, and it's bipartisan, that there's a real interest in creating an environment where we can try things without kind of losing control of the regulation piece, and without like opening the floodgates to things. I think that aspect is embraced over there at the General Assembly. We also know that there are some key folks at both courts, Court of Appeals and Supreme Court, who are in favor of this kind of thing, of trying some things, doing things differently, that I think if we went this route, we would definitely want to partner with them in some way, or elicit their support for this. I've never been a big fan for going to the General Assembly and saying, hey, let's look at what's in Chapter 84. But I think this one could be done in a way that is tailored and targeted, that we could get some real support within the General Assembly. I think there would be support for the idea that, we're not wedded to doing everything the same way over and over again. And there's been a long history, part of our tension with the General Assembly has been that there are folks there who look at the regulation of professions as being stifling on competition and on other things. And so we would really be kind of playing off of that. That said, I think this is a process, and we would obviously have to test the waters and proceed fairly carefully. But I think what Jeff has pointed out is that there's a potential here to do this. And it enables us, like Utah, to say, well, maybe there's some other ways of doing things that our current structure just doesn't allow for. And this gives us an opportunity to test it without being committed forever on it. I find it really, frankly, exciting. I also, one thing I wanted to address, and Jeff, Summerlin Long, I think you may have implied that we would go, if we were going to do the paraprofessional license, we wouldn't do this, or vice versa. I think we have the bandwidth to pursue both of these things. I don't think they're mutually exclusive. It's going to be a lot of work, and Brian and I have kind of recognized, like, we need to, and we've suggested to another member of the staff that she join us as support for what we're doing here. But I don't think they're mutually exclusive. I think they really are looking at different aspects of the access to justice problem, and it's possible to do both. And then on the money piece of it, it's the same thing. I think it's, we've got to move slowly and sort of test, not too slowly, but test the waters and see what's out there. But we've got a lot of major universities in our area that are interested in innovation, that I think we might be able to partner with them, approach them about it. I think these entities that have provided funding to the Utah program, they may be open to us reaching out to them as well. I think you're right. We want to stay away from maybe private business money, but I think funding from foundations, et cetera, might be there to help us with this. So what I appreciate about Jeff's presentation is that it's taken me from being a skeptic that we could never do this in North Carolina to being a believer that we can, but we'd have to move cautiously because there are a lot of issues we're going to have to address.
Thanks, Alice. Marcy, I think you've got your hand up.
Oh, I think Alice answered a lot of my questions, except that what what do we need? Do we have to go to the Supreme Court first, Alice, to get their blessings before we go to the legislature? Assuming that the council vote, even this gets to the council and it's approved. I mean, what is the role of the Supreme Court?
So Marcy, traditionally, when we've had an issue related to Chapter 84, we have not gone to the court to get any kind of approval in advance. Our dues bill is a classic example of that. However, this is one where I think we would benefit by telling the court, we're doing this, why we're doing it, and making sure there's not opposition there to start out with. We don't want to do anything where the court would feel like we lost our minds or something and would be opposed either explicitly or implicitly. But I think even better is the potential that the court would be supportive of it in some form.
Thanks, Alice. Thanks, Marcy. Other comments and questions?
So what's the next step then, Mark?
Yeah, Heidi, good question. I think the next step is for us as a subcommittee to vote on whether we think this is an idea we want to recommend for further exploration. Assuming, and if we vote yes, the idea would be that I would present to issues and executive, much like I did in July on the limited licensure thing, recommending that an actual implementation committee, probably an ad hoc committee, be set up to actually look at what it would be to implement. And then they'd have to develop a proposal that would be presented to the council. The council would then have to decide whether they are supportive of it, at which time, you would then move forward going to the legislature and the other steps that Jeff outlined. And I think at that point too, you would, want to talk about who's going to be, the administrator, how's it going to work, the funding. There's certainly a number of logistic steps that need to be taken. And I think that's beyond the scope of this particular study group. So if we say yes, it would then go to a new committee to hash out some of those details, much like the limited licensure. And again, to echo what Alice says, I agree completely. I think we've already recommended that. I think a committee is going to get appointed to develop a proposal around limited licensure. I think that can happen in parallel with the Sandbox idea. They're not exclusive. I think they are two very different reforms that both I think have merit, and I think it's worth developing. And again, both of those committees will have to develop what the proposal is before the State Bar Council can decide yes or no whether they really like it. So this is not today's vote, certainly not a vote to implement some regulatory sandbox. It's just does this group, based on what we've learned from Jeff and the earlier presentations, think this is an area worth developing a proposal on, I think is really the test. And so I'm getting ready to call for a vote, but I want to make sure everybody else wants to either have questions or comments or pro and con, anything they want to share. We have time if you want to.
Hey, Mark.
Yes, Todd.
I've been scrolling through the presentation here. First, I want to say, Jeff, thank you very much for that great presentation. It was very well done and very informative. And I'm in agreement with what's been said here. I guess I have a question about one of the slides and the foundations here. Did I understand correctly to say that I know Utah has the sandbox, others have studied the idea, but no one else has gone forward so far? California is studying it right now. There've been a couple of reports issued. I thought one of your slides said, do we have any, you talk about experiments, and I agree with a lot of experiments. Do we have any more experiments in existence other than Utah right now? And if we don't, is it right to go forward with the recommendation, in your view, without having a bit more experience, so to speak, so that when we come out and make the recommendation, we can point to successful sandboxes that support our recommendation?
Sure. So answer the two parts. First is, in addition to Utah, there are two active sandboxes, one with approved entities in British Columbia. So they've been fully approved. They've received applications. Their initial pilots have been approved and issued no action letters. there is an approved but not yet fully launched in Ontario, which is, again, they're soliciting applications through September. So by the time that this, on the earliest track reaches the State Bar Council, hopefully we'll at least know who those initial participants would be and the makeup of that.
Let me ask you. Let me
Sure.
ask you. I don't want to interrupt. I'm trying to sort of think as you talk, and I apologize for interrupting. Could someone's, and I saw that slide that folks up in Canada had programs in place. Could someone look at those sandboxes and say the way the legal system works in Canada is night and day from how it works here in the US, and so that's really not representative of what we would be recommending to do here in the US, or it's not really similar or analogous to what's going on in Utah? I'm asking. I don't know the Canadian system.
So I'll put on my comparative law professor hat and say there are plenty of differences even among the provinces. But what I think would be, part of why I feel comfortable putting them out there as examples or illustrations of what this could look like is the types of problems that they are seeking to address, mainly those that are centric around a difficulty in getting access to civil legal needs.
Right.
That's central, I think, across all of these jurisdictions. The other part is that there are interesting dynamics between the British and Ontario examples where the one of them is implementing a technology specific requirement, which I sort of, my gut reaction to that is maybe that's restrictive, but I'm curious, maybe that's going to encourage more technical applications in a way that is more transformative. And so I think that they're at least worth looking at, even if it's just like you said, it's persuasive. I don't think any of these are binding on how we should do it. Obviously, because I've had the opportunity to dig in so deeply into the Utah, I find the sort of granularity of that compelling, but I'm not specifically wedded to that. So I think at the very least, more information in this context is going to be helpful and can be presented in a way that's hopefully, you all can give me a polling on whether this is overwhelming even here, but point being, it's helpful to give a few concrete examples. And again, it's why I focus more on Utah than in Canada, not just because they're earlier or I guess younger in their existence, but also because one is clearly in a jurisdiction that we can at least make comparable arguments to with basic familiarity.
I would go ahead.
If I could just say a quick thing, Lawyers Mutual is a bar-related insurance company, and we share that distinction with many Canadian companies. There are like 20 bar-related companies in the US and Canada. And so I have annual meetings with these folks, and I find that we have so much in common, and as we're looking at both their Sandbox, they've also got the limited licensing program that's been in effect there for 10 years. So I think we have much more in common in the way that we just talk about law, client issues, challenges, kind of remaking the system. Maybe more in common than we might would think.
Thanks, Camille. Josh Malcolm, I see your hand.
Yes, sir. And I think my comment may be more, like always, from a practical perspective. In light of the fact that we've made some recent recommendations to the council to review some other things, the limited license, and how much, and if this were to be recommended as well, does there come a time when we're oversaturating this thing and asking the council to look at too much? I know folks have referenced in the past when basically we need to swing for the fences if we're going to do some things, but from a practical point of view, because I'll tell you, I've got some informal feedback when folks heard that I was on this committee. There was a lot of questions, and so I guess Jeff, although you did this presentation, if I ask you to put things in hierarchical order, would it be this Sandbox idea, or would it be the other things that we've already recommended? I think I know your answer, but I'll ask it anyway.
in my completely unbiased opinion, I think that this is a structure that can probably accomplish broader solutions, but I'm in favor of both.
I think it's a good, I guess I'll give you my thoughts on that, Josh. I think it is a good question, and it's resources of the council and staff. And so I do think we need to look to Ellis and Brian, as well as the officers and the executive committee, to see how much they want to bite off. I do think, again, we already made the recommendation on limited licensure, and I think that is moving forward. There will have to be a decision whether to move forward on this, as well. I do think, and you're right, we voted on other ideas that we thought are worth some study, and I'm not sure they can all be simultaneously explored. I do think some of those, remember we talked about, easing restrictions on ownership and other stuff. Some of those are the very things that other people have tried to address through a sandbox. So while the limited licensure, I think, is truly a different program, the idea of some of the other regulatory reforms can fit within the idea. We can explore those in the context of a regulatory sandbox, as opposed to a separate investigation on several of the other things we did. But I see Alice's hand up, and I was going to call on you anyway, Alice. I welcome your thoughts on Josh's good question, trying to really be thoughtful about the limited resources we have, at the state bar.
And Josh, I really appreciate that. I think I alluded a little bit to that previously, that I think the council's got the capacity to participate in the committee work that would be involved. I worry a little bit more about the staff, because we're the ones that are paddling under the water typically, to actually accomplish the things that the committee people or the council sets us to do. But I personally think this is some of the most important work that the council may be doing and has done in a while to try to address access to justice. And I would hate to see us, not take the momentum that we have now and that we're seeing really throughout the country in support of these kinds of things, and move it forward. I actually think that the paraprofessional license is a actually more complicated kind of question as to how you do that. The whole question of how you license and, the requirements for licensure and how you regulate is, almost creating something from scratch. Whereas with this sandbox concept, I think we've got a great example in Utah as to how you do that and set up the structure. You set up the structure and then you see if they will come, is really what you're doing there. And so I think, yes, I agree with you, Josh. It's going to stretch us, primarily the staff, but I think we've got the ability to do that. And I think it's an important thing for us to be considering, and we shouldn't shy away from it simply because it's going to require some extra work on the part of the counselors who will be on whatever committee is formed, but also the staff.
Thanks, Alice. I think I see Marcy's hand.
Hi, thanks. What Todd said is really giving me food for thought as well. I do worry that we don't really have a lot of jurisdictions that really have this up and running to learn from. I also think before we spend more and more time and resources on this, I think we do need to get the temperature of both the Supreme Court and the General Assembly. Not sure how to go about doing that, but what I'd hate to do is, we do have a lot of work to do at the state bar. We expect a lot of our counselors. There are multiple committees right now doing all good work, and this included. I'm not saying this isn't very important too, but I'm just kind of wondering out loud. Do we test the temperature at the legislature? We have people over there that are lawyers that we have good relationships with, that we could talk with. We have, certainly, I think we should talk with the Supreme Court Chief Justice about this. I'd hate to see us spend more and more time for something that's going nowhere. So I guess that's my concern. I think it's all very great and great work, and potentially benefit people that need help, but I'm just wondering if now's the time. That's all I have to say.
Thank you, Marcy. other comments? Your hand's still up, Alice, but I think that's from before, right? Anybody? I'm looking to see if anybody wants to raise their hand or come in from the phone. That's harder to do. And I guess I agree with Marcy. I think we'll need to explore that. I think our role is to say, is this worth exploring? I think part of that exploration certainly has to be thinking about the political feasibility of it and both judicial and legislative support. So I do think that would be, that would be appropriate to get a better sense of before we invest a lot of time in nitty-gritty details, is whether there's support. I think many of us have a sense there may be support, both legislative and judicial, to this, but I think confirming that is probably an important early step if we decide to move forward.
Hey, Mark, I
Yes,
guess in light of that, in terms of sequencing, should that type of inquiry to the legislature and the judicial system perhaps proceed or at least inform our vote here? Or are you suggesting simply take the vote and then we worry about that later?
I actually think that probably should precede a formal vote by the executive committee to move forward, maybe an appointed committee, but I don't think, since our role is just to identify areas for further action, I think it's appropriate for us to vote. We haven't been too concerned with the implementation logistics in our committee when we've looked at the other proposals. So I think we can vote today on whether this is an idea we want to recommend for further development. I do think maybe, when that committee, maybe you put some of those people on the committee, but I think exploring with folks, hey, is this of interest and do you want to do it? And see what the Chief Justice says or see what some of the legislative leaders say at a preliminary basis makes some sense. That has to be done carefully, obviously, because you don't want to promise some changes coming if we then vote not to do it. But I think some exploration probably, makes sense there. But I don't think we need to wait here. I think we're voting is on the idea rather than the practicality. Is the idea of a regulatory sandbox something we think is worth action on? So that's what I propose we vote on today.
Okay, thank you.
Now, Alice, your hand really is up again. Go ahead.
I took it down and then I put it back up. We've already had some conversations with Peter Bolak about, what he thought the reception might be at the General Assembly, and identified at least one person on the Supreme Court and one judge on the Supreme Court and one judge on the Court of Appeals that we think would be interested in this development. So my suggestion would be that after this meeting, if the consensus or the vote is to proceed in this direction, make a recommendation to the executive committee, that between now and that time that Brian and Peter and I sort of pursue those things to get a better sense of, would there be a favorable reception? We can certainly do that. The other thing I think we need to do is I had never heard of a regulatory sandbox until I read the report out of Utah. And I was kind of like, what is this? And now it's reached the tipping point, and I hear about regulatory sandboxes all the time. But I suspect that there are plenty of people on the council who are not familiar with the concept, or at least may not understand it in the context of law. And so I talked to Jeff Kelly about this, the possibility of making a presentation to the counselors on it. And possibly doing that as a part of the October meeting. And I think that would be really beneficial so that folks know what we're talking about. And if there's agreement about that, then I'll speak with Jeff and we'll see how we can best schedule that. I mean, it might be the easiest way to do it is by Zoom, as opposed to adding one more in-person event to the October schedule. But if you guys agree, then I think that would be good groundwork, as well as us talking to the General Assembly folks and talking to the people we've identified at the courts.
Thanks, Alice. I do think that'd be great, because I think this takes some explaining, and Jeff did a good job explaining it, but it is, I think people hear sandbox. It's not always immediately obvious what on earth you're talking about with a sandbox if you haven't heard the term. So I think that's a good idea. All right, other comments, questions before we we vote. Brian, did you have a polling question for us? We've probably done everything else using our voting buttons, so perhaps.
I do. I'm ready to go. Here we go.
Sounds good. Has everyone voted? It looks like it's.
I believe that's everybody.
That's everybody. It looks like it passes 10-1. So that's an overwhelmingly positive result here. I'll share the results so people can see the poll. So congratulations. I think we are, and again, this is not voting to implement anything. It is a vote to recommend to the executive committee that they consider appointing a new implementation committee that would actually do that. And I think laying some of the groundwork, both politically and educationally, is probably, is a good idea to do that, to let people understand what it is we're talking about. But it sounds like we're persuaded this is an area worth further development. So I appreciate everyone doing it. I know we've got a lot of interest. I think this is the last major area that I think our subcommittee needs to focus on. The last, what I wanted to wrap up this meeting with is really two things. One is opening it up to other areas that maybe we touched on but didn't get to discuss. And given our discussion about limited staff load, I'm not sure we really want to add a bunch of new recommendations, but I also want to be open, since it's a study committee. People say, hey, wait a minute, you didn't look at, identifying alien species as part of our initiative, or whatever other new idea. It's, now's the time to bring that up and we can talk about it. The other thing that I really would like guidance on, I'd only talked briefly with Brian about it, is what we may want to do in terms of a written recommendation. And I'm glad we've got a lot of our officers here and other people on the executive committee. I don't want to do a lengthy written report if no one's going to read that. We've already made some recommendations, but I also want to try to capture some of what we've done. A lot, though, is captured in the minutes and the great materials that Brian in particular has taken the laboring oar on assembling and circulating. So I welcome thoughts. Is there anything else we should do as a committee other than a report? And if we do a report, I think, Todd, you shared last time some thoughts on what that report needs to, shouldn't say. I welcome comments on that. I have not started drafting anything. I don't think Brian has started either. So I'm welcome thoughts on what we may want to do, because I'm envisioning maybe we have our final meeting, to review and approve of some final report and recommendations. I think we are nearing the end of our work as a subcommittee. So thoughts, and Brian, anything you want to add in terms of, or have I skipped over any other agenda items or issues that?
No. I think this is the next topic to discuss. We have provided a number of reports to this subcommittee throughout this study. As you all know, there are some, well, they vary in length. There are some that are rather short. Oregon provided a nice executive summary that just kind of hit on the topics that they looked at, in kind of a brief description and a brief summary of their recommendation. And then there are some that are rather academic and very lengthy and thorough. But that said, I think there's a multitude of options here. Since I know I'll be participating in the drafting, I guess I'll refrain from offering an opinion on which one I prefer.
Anybody have thoughts? I know we have some law professors in the group too that may like the more academic lengthy report. So, but I really am open to, this is a committee effort. So while I can work with Brian to put something before you, I thought it'd be better to talk rather than draft and then get feedback, thoughts on what it shouldn't contain, how much detail we want to go into. Any ideas on that front?
Mark, this is Colin. I think it would be good. I don't think it ought to be lengthy, but I think it would be good to have a little bit in there about each one of our presenters. And I think there ought to be a record of the number of folks that have come, and maybe a sentence or two about each one, just for someone else picking this up to look at the depth of information that we had and the broad range of it. And it may help in later folks who may build on the work of this committee.
That's a great point. And we have done a lot of work. So I think capturing, at least doing enough to reflect the work we've done and let people go back. And obviously the truly dedicated can now, thanks to COVID, can watch most of our deliberations on the YouTube channel. So we can, people that are really interested can really see what we've heard and been presented. I think, Brian, I think almost all our meetings have been that way, right? This is one of those committees.
All except the very first one.
Yeah, the very first one
was
was pre-YouTube, but after that, all our work has been recorded for posterity there. Todd, do you have thoughts? I know you shared thoughts last time, Todd, on the report. I wanted to see if you had anything else to add.
No, I mean, my thoughts are consistent with what I said last time. And I agree with Colin that it would be nice to recognize the depth of resources and the wonderful presentations that this committee has had the benefit of. So I think however you put that in the report, I think certainly ought to be in there. I agree with that.
Great. Camille, sorry, I interrupted you.
No. I'm always a fan too of reusing material as much as you can. So, maybe the report becomes, a little more reader-friendly article for the journal. And then that becomes, the basis for a PowerPoint that, people could travel around the state and do. So, I think I would prefer it to not be so academic that it would sort of sit on a shelf and never be viewed. I really like Jeff's format today and this format that a lot of our speakers, have done. PowerPoints are kind of easy to read and move through.
Great. Jeff Summerlin Long.
Sorry, as an academic, maybe I feel like I should defend myself. I mean, I actually agree. And what I think is going to be useful, I think the main document itself should be brief, right? Clear, concise.
Right.
I am all for liberal use of appendices.
Yes.
And then, people can go into whatever depth they want to go into. But I do think it's an important service for us to provide that level of depth on these things that we've gone into in depth so that they don't have to, right? And so should this report go up on like a home website or something like that, you can have
I don't like that website idea, Jeff. Sorry.
Yeah, no, I don't like that one at all. Anyway, we can have links to the appendices, so that people don't have to be bothered with them if they don't want to.
Yeah, that's a great point. And it is one beauty of the electronic age is we can link to the minutes and the videos and other stuff, they don't have to be part of the report through hyperlinks and other stuff. Well, that sounds good. Heidi.
The other thing, Mark, is, we've all been enmeshed in this for what has it been, a year and a half? And there has been a lot of really pretty complex information shared. And so when we're presenting to others or to people who might pick up the work from here, I think it's pretty important that not only are you identifying the breadth and, cumulative knowledge of the folks that came and talked to us, but I also think even in the original, I agree with the appendix idea, but even within the body of the original report, you say, all right, these are the things we looked at. Here are the 10,000 foot level. Here's what it is. Here's what it does. Here's why it's good. Maybe here's why it's not so good. Here's who's done it. Like some distilled bullet point list of what each thing is, because it is not obvious, going back to the name Sandbox. I mean, like Alice said, we've heard it in a lot of other contexts, but it's a little bit almost intangible in a legal context. So I think I agree with short, but you have to have the information for people to evaluate what has been done. And then ultimately, the end recommendation and the why.
Great. That's good feedback. So thank you. Thanks everybody for that. And so I will work with Brian to put together one that I hope encapsulates those ideas and the good work we've done in a usable presentable format with good appendix references. And so we'll try to work on that. Don't know the timing. I'm not going to pre-commit to anything on either of that. And then with the idea though that we'd circulate that and then have a final kind of wrap-up meeting, look at all the stuff we've done, the conclusions we've reached, here's a draft report that we can get final feedback on and try to approve. So I think that will actually move towards bringing the work for this committee to a close. In the interim, the action item, what we voted on, I will present to issues and executive in October at those meetings, and then they can decide how to take that ball forward on the regulatory sandbox. Thanks. I share my thanks, Jeff, to the great presentation you've done today. A lot of great information and clearly a lot of work behind it. You and your other committee members appreciate that work and digging into a complex topic and really bringing us something with real meat on it so we can get a sense of what it would look like. So I thought it was terrific. So thanks again for your continued, you guys have put a lot of time in this subcommittee. So my thanks go out to all of you for your continued attention and service. These are important issues that have the potential to really change the way law is practiced and bring access to a lot of people that don't access it. So I appreciate your time and effort in this and look forward to seeing you next time. Try to stay safe out there and appreciate everyone joining us today. Thanks a lot.
Hey, Mark.
Yeah. Yes, Todd.
And just to you, thank you for your excellent leadership. You've done a great job leading us.
Thanks. Been my pleasure. Thanks, everybody. All right.
Thanks.
Thanks. I'm happy to stay on like I usually do if we want.
Yeah, no, I thought that was a pretty good. Oh, Alice, you're muted right now.